Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 82. This week we've got three cases, and the first of them, the EAT looks at what might be considered to be parallel treatment of employees who are in very similar disciplinary situations, and whether different sanctions given for basically the same misconduct could render a dismissal unfair. Secondly, we've got an EAT decision looking at whether it's necessary for an individual to have suffered a detriment in order to bring a successful discrimination claim. It's an important point for reasons I'll explain. Thirdly, we've got another EAT decision, so it's a full house of EAT decisions this time, in which the Employment Tribunal's decision that a dismissal for ill health reasons was unfair was overturned. And in coming to the decision, the EAT looked at the factors an employer should consider when deciding whether to dismiss, and the key issue being that the tribunal had to look at whether the employer could have been expected to wait for longer before taking the decision to dismiss. As always, please don't forget, we have, in addition to this podcast being available via the Mayor Brown internet site, we also have obviously up on iTunes, on YouTube, and it can be accessed. The links and so on are on Twitter, as are the case links. Don't forget, I put the links to the cases I mentioned go up on Twitter when this podcast goes live. Also, in relation to YouTube, keep an eye open for the YouTube broadcast that we're doing, introducing our global book on background checks for employers in about 60 countries around the world, where our global PSL, Louise Fernandez-Owen, is going to be recording a short piece explaining what we have done and why. So, on with the show. MBNA Limited and Jones. This is an EAT decision considering disparity in the treatment of employees and the sanctions given for the same misconduct, and whether that could render the dismissal of one of the employees unfair. As a background comment, it's surprising how often the alleged inconsistent treatment of employees who are engaged in similar misconduct actually comes up. It's a point that the employees often raise themselves, particularly the one who feels he's been treated too harshly. Surprise, surprise. However, the courts have been, in my experience, relatively reluctant to get involved with setting tariffs or requiring employers to apply standard or uniform sanctions for particular types of misconduct, unless it is really indistinguishable. Let's face it, there are usually distinguishable elements to any set of misconduct facts. However, in this most recent case, we see the EAT cut down even further the scope for an employment tribunal to rule that a dismissal is unfair just because of a more lenient sanction given to another employee. So, facts of the case were that Mr. Jones, an employee of MBNA, attended an MBNA social event to celebrate the company's 20th anniversary. Employees were expressly told this was a work social event. Normal standards of behaviour would apply, as set out in MBNA's disciplinary procedure. Well, during the event, Mr. Jones fell out with another employee, resulting in a tussle in which Mr. Jones punched the second employee in the face. Maybe a bit more than a tussle then. He punched the second employee in the face. Later that evening, at a completely different venue, that employee sent Mr. Jones some very violent and abusive text messages from outside the venue, but in practice never acted on his threats to Mr. Jones. MBNA carried out disciplinary investigations against both employees. Mr. Jones was summarily dismissed, and the other employee, the one who'd merely, quote unquote, given the very aggressive text messages, he was given a final written warning. Mr. Jones appealed his dismissal. Appeal was rejected. Pursued a claim for unfair dismissal against MBNA. Well, the Employment Tribunal found that Mr. Jones' dismissal was unfair. The tribunal said that different sanctions had been applied, i.e. the dismissal for one and the final written warning for the other, made the dismissal unfair. Also, they felt the company handled the issue of the extent to which each man had been provoked by the other's behaviour in an inconsistent way. The tribunal concluded that had both employees been dismissed, then both dismissals would have been fair. This was on the grounds that both sets of acts were definitely acts of gross misconduct. But the tribunal said that the dismissal of one was unfair because there was an unreasonable disparity of treatment between the two individuals. Well, MBNA appealed to the EAT. The appeal was upheld and the dismissal was held to be fair. The EAT looked at the case of Hadjianu and Coral Casinos, in which it was decided that the circumstances where inconsistent treatment can be relied on in a dismissal scenario, if you're going to do that, it's necessary to consider whether the facts of the cases are truly comparable. In the Hadjianu case, the EAT held it would be unusual for two separate incidents of misconduct to be identical, and therefore consideration had to be given to the nature and degree of the acts of misconduct, the employee's own attitude, and any individual mitigating circumstances. And that really goes back to what I was saying about there are always distinguishing factors. Well, in the MBNA case, the EAT decided that the Employment Tribunal had erred by not following the Hadjianu guidance. It concluded that the tribunal had departed from the statutory test of reasonableness, and had the reasonable bound of responses test and the Hadjianu guidance been followed, the tribunal would have recognised the differences between the two employees' cases, and the difference in treatment would therefore have been within the band of reasonable responses. The EAT pointed out the two individuals faced different misconduct findings. One was about an employee making threats, the other was about the employee actually carrying out physical acts of violence. It wasn't therefore unreasonable for the managers to treat these acts differently, and the fact that one sanction was more lenient did not render the other sanction of dismissal unfair in the circumstances. And one of the interesting comments the EAT made, and this is the bit that really sort of stood out for me when I was reading the case, was that it was fair and reasonable to dismiss the employee, and if it was fair and reasonable to dismiss the employee, then the fact the other employee was treated more leniently was irrelevant. That's quite a bold statement. It's an entirely logical one. The focus is on the employee who's bringing the unfair dismissal claim, not the other employee. And this is particularly helpful for employers, for example, where the issue is not two employees who are guilty of similar misconduct in the same incident or on the same evening as here, but two employees who are maybe facing disciplinary sanctions in respect of similar matters, which occurred, let's say, a year or more apart, where the company struggles to remember precisely why the earlier, more lenient sentence was given to the first employee, in my example, when it's looking to dismiss the second employee. Similarly, the EAT pointed out the suggestion that the provocation defence had been handled differently by the company in each disciplinary hearing really amounted to a statement by the tribunal judge that the tribunal judge did not agree with the decisions taken by the employer, since the relevant test for unfair dismissal is not whether the employment judge agrees with the employer, but whether the dismissal was within the bound of reasonable responses. The tribunal judge, in my terms, had overstepped the mark. Well, although the case does provide more, wiggle room for employers to treat employees differently, there are still boundaries. Clearly, following both the tribunal and the EAT's comments, an employer should ensure in properly parallel cases that it undertakes a fair and thorough investigation and disciplinary process before imposing sanctions. Equally, the decision as to what sanctions should be imposed obviously needs to be carefully recorded, and where different or disparate sanctions have been given, the reasons why this has been done should be documented, although I suppose there might be an issue as to whether it was appropriate to convey to the employee you're dismissing why you're not dismissing employee B. Anyway, in terms of the general sanctions, it's particularly important where historically an employer has always taken a particular approach with regard to sanctions for certain behaviour, because it's very important if you're going to then depart from that or feel that they're aggregating features, that those are clearly brought out. And this approach would assist if the employee questions the fairness of the dismissal on grounds of alleged inconsistency. It's sensible in any event, frankly, for employers to consider consistency in the process, but it may not always be appropriate or possible to consider that like cases are dealt with consistently if the circumstances are really different. The other point to bear in mind is that if an employee is arguing that the disparate treatment was motivated consciously or unconsciously by unlawful factors such as race or gender, then a tribunal is much more likely to scrutinise the disparate treatment and require the employer to justify its approach in relation to both sets of disciplinary sanctions, in this case, had, for example, if race had been an element. So, that's the case of MBNA Limited and Jones. Next up, Singh and Cordant Security Limited. Well, this is an EAT decision looking at a failure to investigate a fabricated grievance and whether that failure to investigate could still amount to discrimination under the Equality Act. Well, quick legal background. Section 39(2)(d) of the Equality Act 2010 provides that an employer must not discriminate against an employee by subjecting the employee to a detriment. Direct discrimination is defined as arising where A discriminates against B if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. Background facts, very straightforward. Mr. Singh was employed by Cordant as a security guard. He was of an Indian ethnic origin. Allegation was made that he smelled of alcohol at work. Subsequently, he was sent home whilst the allegation was investigated. Following this decision to investigate, Mr. Singh made an allegation that his supervisor, a white male, had used racially abusive language towards him. Cordant did not take any steps to investigate Mr. Singh's complaint, and Mr. Singh brought a claim to the Employment Tribunal that he had been directly discriminated against. Mr. Singh argued that because Cordant had not investigated his allegation of racial abuse, but it had investigated the allegations into his alcohol intake, he had been treated less favourably on the grounds of his race. Pausing there, it's important to highlight a key fact in this case, which was that key finding, which was that all the allegations raised by Mr. Singh were found by the tribunal to be false and had been completely fabricated by him. So, the key question was whether they could still be direct discrimination under Section 39(2)(d) of the Equality Act, even where the conduct complained of did not happen. Well, the tribunal held that Mr. Singh had been subjected to direct race discrimination. However, the tribunal went on to find that Mr. Singh didn't suffer any injury to feelings as a result of the failure to investigate, because his complaint was false. Therefore, he was not entitled to any compensation. But the Employment Tribunal instead made a declaration that Cordant had directly discriminated against Mr. Singh by failing to investigate his allegation of racially abusive bad language. Cordant Securities appealed to the EAT, not surprisingly. The EAT allowed the appeal. It decided that in order to find there had been a breach of Section 39(2)(d), there had to be discrimination, i.e. less favourable treatment on the grounds of a protected characteristic and detriment suffered. As the Employment Tribunal already found that Mr. Singh didn't suffer any detriment because his claim was entirely fabricated, the EAT considered it had no option but to conclude that the entire claim failed, as the key element of the statutory test had not been satisfied. However, the EAT did make the point that even if a grievance was bound to fail, that did not exclude the possibility of there being a detriment. It's possible for an employee to show that they've suffered an injustice and injury to feelings, even in circumstances where the grievance was bound to fail. Well, look, it's obviously unlikely that we'll come up with many situations where an individual has suffered less favourable discriminatory treatment, but has suffered no detriment. Here, of course, the case was very fact-specific. Mr. Singh was found to know that he was lying and making up the allegations. He'd fabricated the allegations, which presupposes he knew what he was doing. Therefore, it's understandable that a tribunal, having reached that finding, would want to avoid giving him the satisfaction of even a notional win. I also think it's very important that the EAT emphasise that just because a grievance was bound to fail, this does not mean that it can be safely ignored. If Mr. Singh, instead of these facts, was found to have been wrong in his recollection, or what he heard may have been mistaken, and so his grievance was always going to fail, it doesn't mean that he wouldn't have a legitimate sense of grievance if the company had not even bothered to investigate. In other words, in general terms, it would be very dangerous to ignore allegations or a grievance just because the employer considered the allegation was groundless and was necessarily going to fail. Additionally, of course, matters have a habit of developing. Investigations throw up different evidence, different recollections and different perspectives, etc. So I think this was very much as a retrospective step, but certainly had I been contacted in the run-up to this, I'd have said you want to investigate even if you think it's utterly groundless. In essence, I think the case is a useful reminder of the need to treat employees consistently, and that it may well be deemed discriminatory if you have an employee who raises an allegation which is investigated straight away, but another employee with a protected characteristic who raises an allegation which is not investigated at all. The tribunal and the EAT certainly didn't have any difficulty in finding that the approach taken by Cordant Securities in respect to the two employees constituted less favourable treatment. So that's Singh and Cordant Securities. Third and last in our trio of EAT cases, Monmouthshire County Council and Harris. This EAT decision looks at the factors an employer should take into account before dismissing an employee for long-term ill health absence. In this case, the claimant, Mrs. Harris, was diagnosed with 4 chronic conditions, worked partly from home as a reasonable adjustment made on account of her illness. She had 3 occupational health reports over a period of time, which confirmed or recommended that working from home was a suitable, reasonable adjustment. However, in 2010 she was allocated a new line manager, who was the focus of a number of complaints from Mrs. Harris. Sometime later, the new manager withdrew the home working arrangement and prevented her from working at home. Following this, she went off on sick leave, during which she claimed she was being bullied and harassed by her new line manager. During the period of leave as well, Mrs. Harris attended further occupational health appointment, which described her condition as chronic and likely to meet the definition of disability under the Equality Act. The report confirmed that Mrs. Harris was unfit for work in any role at that time, and that it was unlikely that she would be able to provide regular and efficient service in the future. The occupational health advisor was unable to provide any clear indication as to when she might be able to return to work. A meeting was held with Mrs. Harris and the council in which she was told the council would be unable to support her sickness and absence indefinitely, but the risk of dismissal was not spelled out at that point. Following this, she raised complaints regarding her line manager, specifically with the council, who pointed her in the direction of her policies and procedures for supporting employees, but did nothing to initiate an investigation of her complaints. Well, at that point, the council took the decision to terminate Mrs. Harris's employment, and the decision was sent out to her in a letter confirming the council's decision to dismiss on grounds of capability due to ill health. Mrs. Harris subsequently applied for ill health retirement, relying on the occupational health report and her GP's report, which confirmed that there was only a remote chance of her returning to work. Neither report confirmed that she was permanently incapacitated, and the application for ill health retirement was therefore denied. Well, she obtained a further report confirming that she remained unfit for work for the foreseeable future, but following this she brought claims in the Employment Tribunal for harassment, unfair dismissal, failure to make reasonable adjustments, and discrimination arising from her disability. So, how did she do? Well, the Tribunal concluded that her dismissal was unfair owing to procedural failings on behalf of the Council in the run-up to dismissal. It held that her dismissal was discriminatory, as it had been done on account of her absence, which arose because of her disability. According to the Employment Tribunal, the Council provided no justification for the dismissal, and no consideration was given to its own failure to make reasonable adjustments, the home working bit, which the Tribunal held had caused her absence, which ultimately led to her own dismissal. She was awarded almost £240,000 in compensation, but the Tribunal rejected her claim for a failure to make reasonable adjustments, stating that the reasonable adjustments claim was out of time, and there were no reasonable adjustments that could have been made at the time of her dismissal. That's important. There were no adjustments that could have been made at the time of her dismissal. Well, summarising this, so the factors found by the Tribunal were the Council probably should not have withdrawn her home working because that amounted to a reasonable adjustment. However, she couldn't complain about that withdrawal. But the withdrawal had led to the deterioration of her health. By the time of her dismissal, there were no reasonable adjustments that could be made. So what was the EAT going to do? To what extent did the earlier failures in relation to her home working mean the Council was prevented from dismissing her? That was really the key question. Once it had been framed in these terms, given the Council was then being asked to wait a number of years, according to the medical reports, it was difficult to assert the Council could have reasonably been expected to wait longer. One of the doctors, remember, had said there was a very remote chance of a return to work. The EAT, who upheld the appeal by the Council, in coming to its decision, the EAT criticised the Tribunal for failing to follow the guidelines set out in BS and Dundee City Council in respect of the unfair dismissal claim. As confirmed in the EAT's judgment in that earlier case, the legislation required a tribunal to take into consideration whether the employer should have waited longer before dismissing, whether any consultation was carried out with the employee prior to dismissal, and if the employer obtained up-to-date medical advice before making a decision to dismiss. In terms of the fairness of the decision, the tribunal had instead only considered the previous failure to make reasonable adjustments, the home working point, and not taken into account all of the other circumstances of the decision to dismiss. And the EAT's view was that the tribunal therefore failed to address the fundamental question of whether the Council could reasonably have been expected to wait longer before dismissing Mrs. Harris. In relation to the earlier failure to make reasonable adjustments, the EAT held that there was no continuing obligation to make those reasonable adjustments at the time of Mrs. Harris's dismissal, and that was the Tribunal's own finding, that at that point there were no reasonable adjustments that would have got her back to work. The Tribunal had therefore failed to consider whether the dismissal was a proportionate means of achieving a legitimate aim. As for the discrimination arising from disability claim, the EAT concluded that Mrs. Harris had been dismissed for her sickness absence, which was arising from her disability. The earlier failure to make reasonable adjustments was part of the background to be taken into consideration, which may have resulted in Mrs. Harris being unable to return to work. However, it should only be considered if the tribunal recognised that there was no continuing obligation on the council to make the adjustments at the time of the dismissal. It was effectively necessary to disentangle the home working decision and the decision to dismiss. The tribunal's decision was therefore flawed, as it had failed to take into account proportionality, and on that basis, the appeal was allowed. I think the case it's a useful reminder for employers of the need to carry out a full evaluation and ensure that they document the process as to whether the decision to dismiss is reasonable and a proportionate means of achieving a legitimate aim. This will assist in the unfortunate circumstances of any dismissal decision coming before a tribunal and help to determine the question of reasonableness. In carrying out the evaluation, employers should consider whether all possible reasonable adjustments that would facilitate a return to work have been thought of and whether sufficient consultation with the employee has been carried out. However, the EAT was very clear that the mere fact of the earlier findings on the employer around continuing home working arrangements did not mean that the unfair dismissal or the disability discrimination claim from Mrs. Harris would necessarily succeed. It might be relevant to the background, but it did not mean, for example, the dismissal was going to be unfair or discriminatory. The employer's medical evidence did not indicate that returning to the former home working arrangements would have enabled her to carry on working in any event. I think what really did for Mrs. Harris was that initially she tried to get an ill health pension, which required to bring out and bolster the evidence that she was unlikely to return to work, and when she was unable to obtain the ill health pension, she was then left trying to argue that it was unreasonable for the employer not to keep open her employment for longer. This dilemma does face claimants, and sometimes it can make it very difficult for them to decide whether to go for continued employment, that has been the target, or an ill health pension. So that's the case of Monmouthshire County Council and Harris. So I think all it remains for me to say is thank you very much for listening to the podcast, and in what has obviously been a very sombre period since we last spoke. Thank you for listening, and stay safe, and hope to speak to you again in 2 weeks' time. Thanks very much indeed.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.